We are very fortunate to have on our panel today two of the smartest lawyers in the music business. Bob Clarida is a partner in the law firm of Reitler, Kalis, and Roseblatt, I hope I got that right, where he litigates and counsels clients in a wide variety of industries, including music, film, software, and new media. He's the author of the Copyright Law Desk Book and a frequent speaker and author on copyright topics, including the regular copyright law column in the New York Law Journal, and he also serves as an adjunct professor at Columbia Law School. Welcome, Bob. And Andy Tavel has been an entertainment...
That's a smart guy.
Andy's been an entertainment lawyer for over 29 years. He's an ardent advocate for creators and entertainment entrepreneurs, providing counsel and legal representation in a creative and collaborative manner to clients who span the spectrum from emerging talent to iconic superstars and from established entertainment companies to startups. Andy's actively involved with the NARIS New York Chapter Board of Governors and is also on the board of directors of the T.J. Martell Foundation, the music industry's largest charity committed to finding a cure for cancer. So, Andy and Bob, happy to have you both with us today. Let's get started with the basic types of agreements that songwriters have to choose from today. Let's look at this first one, a standard songwriter agreement. Bob, you want to just give us a brief overview of what that entails, how it works?
Well, yes. Generally, the copyright owner, the songwriter, assigns the copyright to the publisher for a period of time. And during that period of time, the publisher will work to exploit the copyright, presumably, and to place it in films, get it recorded, do things to make it productive, because that's the only way anybody makes any money, is if the publisher is out there working the song. And typically there will be a publisher's share and a writer's share of income that is split evenly between the two parties in that arrangement. And the publisher will take out certain expenses, costs that it incurs, but otherwise is splitting the revenue evenly between itself and the writer. And that includes performing income, that includes mechanicals that are generated by the song from the sale of records, other forms of exploitation. And typically in an agreement like that, the songwriter really needs to know that the publisher is going to be committed to doing something with the song. And very often publishers will try to be as minimal as they can with the obligations that they're taking on, because they don't want to have a lot of boxes to have to check, so that they have to, And
is it common that the ownership of the copyright is transferred to the publisher in that case, so the publisher becomes the copyright owner?
Well, it can work. It can work different ways, but very often there will be an assignment of rights to the publisher, or the publisher will register the work in the writer's name and take care of the registration details. But it's a matter of how fully the copyright is assigned, and sometimes just certain rights can be assigned and others will be held onto by the songwriter. The copyright used to be indivisible under the Copyright Act going back before 1978. So that only the entire copyright could be conveyed. But now you can parcel out different rights to different entities, and publishing agreements will very often only operate with respect to certain rights and not others. Grand rights, for example, which are for live stage and opera and musical theater and so on, very often would not be conveyed in a standard publishing agreement.
Okay. Andy, you want to add anything to that before we start talking about the co-publishing deal?
Songwriter agreements tend to be not used very commonly. They're probably more prevalent still in Nashville. That's the only place they're probably used, because that's much more of a writer's town where there's a lot more song plugging going on. The norm these days is a co-pub agreement followed by an administration agreement.
So when you say a songwriter agreement, you're talking about a strict 50-50 split between what the songwriter gets and what the publisher gets. And you're saying that's not very common, even for even for aspiring first-time writers?
Not even for aspiring.
Really?
I mean, I tend to look at it, and I don't know if you can see it, and this is horrible, my circles. One is the songwriter share and the other is the publisher share.
Yeah.
In an admin deal, songwriter share is one circle, publisher share is another circle. Then I love circles, because then you can also take it and do a pie chart where you have the songwriter share as one and publisher share. So when you do a co-publishing agreement, what you're doing is you're dividing the publisher share. So there's 50% goes to the songwriter, and then half of the publisher share goes to the songwriter. So the difference between a co-pub agreement is this: essentially, you give up half of your copyright for 75% of the income. The other one, the songwriter share, you just keep that portion, your 50%, and the other 50% goes to the publisher.
So we've got a slide up here that shows a publisher and a writer kind of each splitting the publisher's share. So in a sense, the net to the writer becomes 75%.
Correct.
And the publisher is getting 25%.
People get confused when they think it's a co-publishing deal. They end up with half of the income, and the other half goes to the publisher. That's not the case. And the way the agreements are drafted, including the one that's in the material, you'll see that it looks like a 50-50 split, but then you'll realize that initially the songwriter share goes entirely to the songwriter, so then it's a 50-50 split of the publisher share. So it's a little bit confusing when you read those agreements, and people get very upset because they think in a co-publishing agreement they're actually giving up half of the income. That do it?
Yeah. No, I think that's right. So in that case, you having trouble hearing us? We'll speak up. Okay. So in that case, the actual copyright is split between the. I'm curious and I'm concerned about the actual ownership of copyright and how that who ends up with the ownership and essentially the control in a
That's two very different things.
Okay,
there's
good.
Ownership and there's administration.
Okay.
Because you can do a co-publishing agreement where you give up half of your publisher share, and half the copyright. But 100% of the administration typically is with the co-publisher. You'll see that in the agreement that it's with the co-publisher, but then good lawyers will carve back some of the administration rights, so there's sort of a check on what the publisher can do. So it's co-publishing, sole administration is the normal agreement in this day and age, with certain exceptions being pulled back.
Okay.
So as far as ownership, which you'll see is the difference between this and an administration agreement, that's where the play actually is, because there's a lot of overlap between the two agreements. Songwriter agreement, songwriters are pretty well neutered, shall we say.
Okay, and for those of you who are online, we did put Andy was kind enough to work all night long on a new version of the co-publishing agreement, which is up on the website. Again, it's on the Learn More tab, and if you scroll down, you'll find the co-publishing agreement. And I noticed in there that as you say, a lot of things are clawed back for the writer. For instance, the right to approve synchronization deals and things like that. Is that common? I mean, is it? And what other kinds of caveats could be put into a co-pub deal?
I mean, using that
anything's possible.
That one's a particularly wonderful example with synchronization licenses, because if the publisher has written a significant advance, they will want to maintain as much control and limit the approval rights that the songwriter will have. If you have gotten a $100,000 advance and there is a commercial that comes down the pike that's paying $50,000, they're not going to want you to be Neil Young or John Mellencamp and say, I'm sorry, I will not approve that particular license, because they're in the business of making money, so they would like to get their money back. On the other hand, when some of the more sophisticated deals that I've done, if the artist is in a recoup position, the approval rights can be absolute. If they're in an unrecoup position, then there's certain approval rights. There's a balancing act that takes place. There are some lower level approval rights, such as background music and things like that, that is just too cumbersome to go. This is the publisher's argument. By the way, since I've represented publishers and songwriters, I can make arguments on either side. I see the validity in both, sorry to say. Yeah. So, you have to ask me which hat I'm wearing at a particular point of time. Certain licenses are so minimal. We get $500, $1,000 sync licenses, and the publishing companies, because they've cut back on the number of people, just do not find it worth their time getting approval. Approvals take too long. In the urban world, we'll have five different writers on some of these songs. It would be impossible for MTV to clear some of these rights if they had to go to each and every person. So for certain minimal licenses, there is no approval. Again, sophisticated. On the commercial side, there may be certain carve-outs that are absolute, such as political, alcohol, certain other illicit activities, not illicit activities, I take that back, where the approval rights are far greater because they're sensitive to the fact that people may have moral issues with the publisher granting approval, but things that are not in this sort of category of 4, then the publishing company has more control, or I'm sorry, fewer approvals that they need to get from the songwriter. Does that all make sense?
Makes sense to me. I'm hoping it makes sense to our audience, and if it doesn't, I'm sure they're going to let us know.